Good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law Number 2. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law Number 2. Today we have our docket set for what is called an arraignment. You have been asked to come here for an arraignment because you have a case in County Court at Law Number 2. What the arraignment is, it's an opportunity for the court to tell you what you've been charged with, what your rights are, and what options you have concerning your case. The case that you have here in County Court at Law Number 2 is a misdemeanor case. Criminal cases are divided into felonies and misdemeanors. Your felony cases are your most serious type cases. For example, felony cases are divided into 5 categories. You have a capital murder, first-degree felony, second-degree felony, third-degree felony, and a state jail felony. Misdemeanor cases are divided into 3 categories. You have a Class A misdemeanor, Class B, and a Class C misdemeanor. Now, for your felony cases, if you're convicted of a state jail felony, the range of punishment is anywhere from 6 months in the state jail to a maximum of 2 years in the state jail, fine up to $10,000. If you are convicted of a third-degree felony, the range of punishment, minimum is 2 years, maximum 10 years. So it's 2 to 10 years in the state penitentiary and a fine up to $10,000. If you're convicted of a second-degree felony, the range of punishment, minimum 2 years, maximum 20. So it's 2 to 20 years and a fine up to $10,000. If you're convicted of a first-degree felony, the range of punishment is minimum 5 years to a maximum of 99 years to life. Then the fine is up to $10,000. Now, if you're convicted of a capital murder, the range of punishment is anywhere from, well, the range of punishment is life or death if you're convicted of a capital murder case. Now, you don't have to worry about that. Why? Because your case is not a felony case. You have a misdemeanor case. And as I mentioned earlier, your misdemeanors are divided into 3 categories, the Class A, the Class B, and the Class C misdemeanor. If you are convicted of a Class C misdemeanor, now your Class C misdemeanors are cases that are handled in the JP court, which is the justice court, or the municipal court, which is the city court. And they come to this court when they are appealed from the municipal court or the JP court. So if somebody have a conviction in city court or JP court, they appeal their case, then it comes here. Now, I said that they handle Class C misdemeanors. Now, with a Class C misdemeanor, the range of punishment is fine only. You cannot get jail time, you only can get a fine. For example, speeding is a Class C misdemeanor. Not wearing your seatbelt is a Class C misdemeanor. So your Class C misdemeanor, you only can get a fine. Now, for a Class B misdemeanor, the range of punishment is from 0 days to 180 days, which is 6 months in the county jail, and or a fine from $0 to $2,000. So you can get a fine up to $2,000 on a Class B misdemeanor, a fine or confinement. Now, for the highest misdemeanor, which is a Class A misdemeanor, the range of punishment is 0 days to 365 days, which is 1 year in the county jail, and or a fine from $0 to $4,000. So you can get a fine and or confinement for a Class A misdemeanor. Now, as a defendant in a criminal case, you have rights. One of the rights that you have is a right to have an attorney. Now, the document that you have in your hand is titled Judge's Explanation of Rights to Defendants Without Attorney. That document uh, states, as a defendant in a criminal case, you have three options. Now, you have three options regarding your right to have an attorney. Number one, you may hire an attorney. Number two, if you do not have enough money to hire an attorney, you may request an attorney be appointed to represent you. Or number three, you may represent yourself. If you want an attorney to represent you and have enough money to hire an attorney, the case will be reset to give you time to do so. If you want an attorney and do not have the money to hire one, you will need to fill out a financial questionnaire so that the proper person can determine whether or not to appoint an attorney to represent you. You may not speak to the prosecutor. Now, the prosecutor is the assistant district attorney, works for the DA's office. Now, you may not speak to the prosecutor about your case unless you sign a written waiver of your right to be represented by an attorney. And that waiver is actually page 2 on the clipboard that you have. Be aware that there are dangers to self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant legal rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. If you choose to proceed without an attorney, you may change your mind at any time and may request counsel, which is an attorney, from the court. At the bottom of that document, it states, defendant's choice, mark initials next to only one choice. If your choice is, I want to reset this case to hire my own attorney, then you will place your initials on the first line to the left. If you have already hired an attorney to represent you, then you will place your initials on the second line to the left and the name of the attorney on the line to the right. If you want to apply for court-appointed counsel, then you will place your initials on the third line to the left. If you have already been appointed a court-appointed attorney, then you will place your initials on the fourth line to the left and the name of the attorney on the line to the right. If you want to waive your right to an attorney and represent yourself, then you will place your initials on the fifth line to the left. Now, once you have finished initialing one of those 5 lines, then you will sign the document where it says defendant, and you will date it today's date, which is August 2nd of 2022. Now, for those individuals who will be waiving their right to an attorney and representing themselves, then you will have to read and sign the next page. And the next page is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. And it states, I have been advised of the nature of the charges against me and the dangers and disadvantages of self-representation. My waiver is voluntarily and intelligently made. Furthermore, I have been advised this 2nd day of August of 2022 by the County Court at Law number 2 of my right to representation by counsel in the case pending against me. I have been further advised that if I am unable to afford counsel, one will be appointed for me free of charge. Understanding my right to have counsel appointed for me free of charge, if I am not financially able to employ counsel, I wish to waive that right and request the court to proceed with my case without an attorney being appointed for me. I hereby waive my right to counsel. And if that is your choice, you will sign on the line that is titled defendant, and you will date it today's date, August 2nd of 2022. Now, as a defendant in a criminal case, you have other rights. One other right that you have is a right to have a trial by jury. Now, where those young people are sitting in that area over there, we call that the jury box. 6 citizens from Jefferson County will be selected to serve as jurors in your case. They will listen to all of the evidence. And then after all of the evidence is presented, they will retire to deliberate. And after they deliberate, well, while they deliberate, they will decide whether or not you are guilty or innocent. Now, you have a right to waive or give, which means to give up your right to have a trial by jury. And by doing so, your case will come before the court, before the judge, in one of 3 ways. It could come before the judge by way of a bench trial. A bench trial means that it's a trial by a judge only, and you do not have a jury. The judge will listen to the evidence, and the judge will decide, after listening to all the evidence, whether or not you're guilty or not guilty. Your case can also come before the court by way of an agreed plea bargain. What a plea bargain is, it's an agreement that you have reached with the district attorney's office to settle your case. If you have reached an agreement with the district attorney's office to settle your case, we call that a plea bargain agreement. The plea bargain agreement will come before the judge, and the judge will decide whether or not to follow or not follow the plea bargain agreement. If the judge does not follow the plea bargain agreement, you'll be entitled to withdraw, which means to take back your plea. Now, if the judge does follow the plea bargain agreement, and if you decide within 30 days that you would like to appeal your case, that is, have a higher court than this court to look at your case, to review your case, to see whether or not you've been wrongfully convicted, whether or not this court committed an error, then the judge has to give you permission to appeal if the judge has followed the plea bargain agreement. The other way your case can come before the judge is by way of an unagreed plea bargain agreement. What an unagreed plea bargain is, it means that you and your attorney have not been able to reach an agreement with the district attorney's office to settle your case. And you want your case to come before the judge so that the judge can determine the punishment in your case. We call that an unagreed plea agreement. And if that's the case, your case will come before the judge, and the judge will determine whether or not, the judge will determine what punishment to assess in the case. As a defendant in a criminal case, you also have a right to have witnesses to come to court. And that area over there where that chair is with the microphone, we call that the witness stand. And what witnesses do, they can testify either for you or against you. If you're representing yourself, you can ask some questions, or if you have an attorney representing you, your attorney can ask some questions. We call that either direct examination or cross-examination. Now, you also have a right to waive your right to have witnesses to come to court. That is, you have a right not to call any witnesses in your case. And by doing so, you will not be calling witnesses. However, that does not mean that the state, which is the district attorney, will not be calling witnesses, because they filed a case against you and they will be calling witnesses. You also have a right, a Fifth Amendment right against self-incrimination. And what that means is you have a right not to testify in your case. You may have heard it referred to as somebody saying, "I'll take the fifth." That means I don't want to say anything. If you exercise your Fifth Amendment right against self-incrimination, which means that you're not testifying, the state, the district attorney cannot force you to testify against yourself. Now, you can waive your right against self-incrimination, which means you can give up your right against self-incrimination. And by doing so, you will be testifying in your case. You also have a right to have discovery. What discovery is, you'll have a right to see the evidence that the state has against you in your case. In essence, you have a right to have access to, for example, if they have videos, if they have tape recordings, if they have documents, witness statements, whatever instruments, whatever evidence, photos, or whatever evidence that they have against you, you have a right to have access to that. Now, you can waive or give up your right to have discovery, in essence, to have access to the evidence in your case if you desire to do so. Now, everyone in here today, you're here, you've been arrested, and you are out of jail on bond. You're either out on a cash bond, which means that you paid the full amount, or you're out on what is called a surety bond, which means that you paid a bondsman to get out, or you're out on a PR bond, which means you was released on your personal recognizance, which means you didn't have to pay any money to get out. Now, every day that you spent in jail, that jail time can be used as credit toward your punishment. For example, if you spent 5 days in jail, and if the state is offering, that's the district attorney is offering to settle your case for 5 days in jail, that simply means that you will not have to serve any more time in jail, because the time that you spent in jail will be credited toward your punishment. Now, if they offer 7 days in jail and you only spent 5 days, that means you would have to do 2 days in jail. Now, if every day that you spent in jail also is credited as $100 per day that can be used toward your fine and court costs. So, for example, if you spent 5 days in jail, that's $500. If the state is offering you fine and court costs of $500, that simply means that you will not have to pay any money, because the time that you spent in jail has already paid it off. Therefore, the fine and court costs will be taxed and retired. Now, if you spent 5 days in jail and they're offering fine and court costs of $700, that means you'd have to pay $200. If you won't be able to pay the $200 on that day, then the court can set up a payment plan or settlement, or you can pay in installments. And that simply means you can make payments each month to pay off the balance of what you owe on the fine and court costs. Now, if you are unable to pay it off because you do not have the income, then the court can convert the fine and court costs to community service. And what that means is, instead of paying off your fine and court costs, you will work off the fine and court costs at a nonprofit organization in the community. Now, every hour that you work on community service, you get $12.50 that will go toward your fine and court costs. So if you work 8 hours, 8 hours is $100. 8 hours at $12.50 an hour is $100 for that day. So you can work 8 hour day, you get $100 that will go toward your fine and court costs. Now, Jefferson County has a program that is called pretrial diversion. Pretrial diversion is a program that's operated through the Jefferson County District Attorney's Office. With the pretrial diversion program, your case is dismissed and you can get it expunged from your record. What that means, expunged means erased, deleted, or wiped off from your criminal history. And the way it works is it has to be your first case. You cannot have a criminal history to get into the pretrial diversion program. You have to have an attorney to assist you, and it cannot be an offense that involves unlawfully carrying a weapon or resisting arrest. And if you get into the program, the case is dismissed, you complete the program, you can get it erased, deleted, wiped off from your criminal history. Now, Jefferson County has a program, another program, when I say Jefferson County District Attorney's Office, has a program that is called Veterans Court. If you are a veteran of any one of the branches of the United States military, the Veterans Court program will allow you to get into the program. Your case is dismissed, you complete the program, they expunge it from your record, erased, deleted, or wiped off from your record. And the only criteria to get into that program is to be a veteran of any one of the branches of the United States military. Now, this court, County Court at Law number 2, has a program that is called the Community Safety Initiative, CSI for short. Now, the CSI program was a program that I started within 100 days of taking office. So the program was started in March of 2017 because I took office in December of 2016. So I started the program in March of 2017, and that program is designed to make Jefferson County a safer place for all of us to live, work, go to school, raise our children, and to go to church. Now, the program is designed to address the issue of what we call recidivism. Recidivism means when people commit crimes over and over. And so how do we stop that? How do we prevent that? Well, one way is through the CSI program. And within the CSI program, we have partnerships with agencies in our community. For example, we have a partnership with Spindletop Center. Spindletop is our local mental health center. And Spindletop, we have some individuals, the young people who are sitting in the jury box, they're from Spindletop, and they'll come to you later on and talk to you. But with that Spindletop program, individuals are given a private interview, they are given an assessment, and a program, a treatment program is developed to address their mental health needs. The program will be outpatient or inpatient treatment. Now, in order to get in the program, you do not have to be incompetent or insane. If you have any mental health issues such as post-traumatic stress, anxiety, bipolar, schizophrenia, depression, ADD, ADHD, or any host of other mental health issues, Spindletop can address it. Now, if you have an issue with drugs or alcohol, if you have an issue with drugs or alcohol, Spindletop has a program that is called ATAR. And then our local Alcohol, Drug, and Abuse Council has a program that is called OZAR. Both those programs can address your drug and alcohol issues, and they will provide you with a screening and an assessment, and then treatment plans will be developed, and you'll be referred to either outpatient, inpatient to address your drug and alcohol issues. Now, if you are unemployed or you looking for a better job, we have a partnership with the Golden Triangle Empowerment Center, who has a partnership with Lamar University. Lamar University has a program that is called CICE. CICE stands for Center for Innovation, Commercialization, and Entrepreneurship. It is a job training and a job placement program in the hotel industry, or the shipping industry, or the chemical industry. Once you are trained in one of those areas, they will assist you at getting a job in the areas that you're trained in. Now, if you have not graduated from high school and you do not have a high school diploma, CICE also has a program that can allow you to get your GED. Now, all of these programs that I've just mentioned does not cost you anything. They are free. Only thing you have to do is have a desire to be in any one of these programs, or a combination could be in one or more of the programs. And the other thing about the programs is all of these programs can be used as community service that can go towards your punishment. So for example, let's say you were given a fine, but you can't pay the fine. And so we convert the fine to community service, right? And you are in the job training program. Every hour that you're in that program, $12.50 is going to go toward your fine and court costs. And then 1 hour is going to go toward your community service. And so, and it's the same way for mental health. If you're in the Spindletop program, while you're in counseling, or while you're in ATAR, one of the drug or alcohol counseling programs, every hour that you spend there, 1 hour is going to go to community service, and $12.50 is going to go toward your fine and court costs. So I tell people this all the time. You'll be killing not one, you will not be killing two birds with one stone, you'll be killing three birds with one stone. And what that means is, while you're in the program, that's one thing, you're getting credit for community service, and you're paying your fine and court costs. So you're doing one thing, but you're getting credit for three things. And all of the programs, as I mentioned earlier, are free. And I tell people this all the time, when you come to county court at law number 2, we do not have court as usual. We have unusual court. And it's not because we're different, but it's because we're making a difference. We're making a difference in the lives of the individuals that comes before the court, this court, and we're making a difference in the community in which we live by making Jefferson County a safer place for all of us to live, work, and go to school. And how we make it a safer place? Because we're producing productive people. And for the most part, productive people do not commit crimes. Why? Because they have too much to lose. And so if you're interested in the program, just let us know, and we'll be happy to assist you with getting in the program. And the other thing I would like to say about that program is, in county court at law number 2, we do not just arrest the problem, we address the problem. And that just simply means we don't just give time, but we take our time. And we believe that by taking our time and by making you productive people, we can make Jefferson County a better place. Now, if you're interested in the program, just let us know, and we'll be happy to give you more information and assist you at getting in the program. Now, I mentioned that we have someone from Spindletop that's going to come forward and talk to you and tell you a little bit about the Spindletop program. We have Deputy Hinton. He's a mental health officer in Jefferson County Sheriff's Department, and he's going to tell you something about the program that they have to offer for Spindletop. Deputy Hinton. You're welcome.
Morning. As the judge spoke, my name is Steve Hinton. I'm a mental health district license in the state of Texas. I'm here with my partner, Sarah. Sarah is a qualified mental health professional with the Spindletop. The reason we are both here today is because the judge cares about every single person that comes before the judge. What the judge has found is those who appear with legal issues commonly have mental health, substance use disorders, or just a lack of resources, community resources out there, and the connection to get to those. And that's what we're here to do. If you don't remember anything else I tell you, we are here to help you. That's our goal. Now, the judge believes, and statistics prove, that if we can help you with any of these underlying issues, should this apply to you, we can get you out of the cycle of risk. Now, maybe this is your first time to be here, maybe it's your 10th time to be here, there's still hope. In fact, we have, Sarah and we have a system in place where we can plug you into the resources that best fit your particular situation. We don't know what that is, so that's going to take a step on your part where you're going to have to do something maybe a little uncomfortable. Maybe you didn't really expect to do that this morning, but you're going to have to reach out and share that need with us so we can speak with you privately. We can speak with you later. But I also want to tell you about this flyer that we have here. It tells you a little bit about what we do on the back side, but on the front side, there's a 1-800 number. That's the hotline number. Should you ever find yourself in an unsafe place, you can get it immediately. I will get this in everyone's hand before you get there. But Sarah's going to speak about this demographic form that she handed out to y'all when y'all came in, just so y'all know exactly what it's going to be used for and how it can actually help y'all.
Good morning. As you walk in, I provided you with this form. This is demographic information. It is HIPAA regulated, meaning that I cannot share this information with anybody else. It's just like when you go to the physician's office. It's protected. Your information here is used to find out more about you, so it can better serve you. Or if you need extra resources, if you are a veteran, that's one of that question is at the bottom, we can provide you with the correct resources. Thank you.
Anybody have any questions? They will be visiting all and a little bit when the judge goes into recess. We thank you for your attention. Thank you, Your Honor.
Okay, thank you, Deputy Hinton and Sarah. Okay, ladies and gentlemen, the paperwork that you have in your hand, if you need help, we have our court personnel here who will be happy to help you with filling out the paperwork. And they're going to, once the paperwork is complete, they're going to pick up the paperwork from you. And then we'll go through the paperwork and then we'll put you into 3 categories. One is if you want to hire an attorney, if you want to see if you qualify for a court-appointed attorney, or if you want to waive your right to attorney and represent yourself. Now, if you are asking to hire an attorney, as I stated earlier, your case will be reset. And if you are requesting a court-appointed attorney, you will have to fill out a financial questionnaire, and we have those financial questionnaires here. And so once we find out who will be applying for a court-appointed attorney, we will provide you with the financial questionnaire. And then once you finish the financial questionnaire, then we will review it to see whether or not you are eligible or not eligible for the appointment of a court-appointed attorney. And for those of you who will be waiving your right to an attorney and desiring to represent yourself, then we will make sure that you have signed your waivers, and then we'll proceed from there. Now, at this time, the court is going to be recessed to give the court an opportunity to assist those who need help and those who do not need help. We're gonna get the paperwork from you, and also those who need the financial questionnaires, you will be provided with the financial questionnaires. So at this time, this court will be in recess to give us time to do that. Oh, and just for the record, we have, I think, Callie Beck is on Zoom. Ms. Beck, you can take your mic off of mute.
Yes, sir.
Ms. Beck, you appeared on Zoom on arraignment. You have to be here in person, but you've already got the information, and so you're gonna have to be here in person so that you can sign the paperwork that we have here in court. And so, she's number 1 on page 3. And so your case is going to be reset. Give us a reset date. Yes. Okay, Ms. Beck, your case is gonna be reset to September 6th of 2022. Make sure you make a note of that, and your bondsman will be sent a notice of your reset date. Stay in contact with your bondsman. You're free to go, and you have a blessed day.
Yes, sir. Thank you very much. September 6th, right?
Yes, at
Okay.
9 a.m. and you have to be here in person.
Yes, sir. I will be there. Thank you.
You're welcome.
All right. Bye-bye.
Now, there's somebody else on Zoom that's named Joycelyn Randall. What happened? Oh, where's Miss? Okay. Okay, Miss Randall, your attorney has not arrived yet, so I guess you can either stay on Zoom or you can Zoom back in. Ms. Randall, can you hear me?
I can hear you.
Okay, so your attorney hasn't arrived yet.
Okay.
All right.